Mr. Klinsky.
Please, my lords and lady, before the short adjournment, I have dealt with two of my three preliminary matters. I was then going to go on to the deal very briefly with the third one, and then get on to the to the submissions. The third one was the "I'm your man" principle. I propose, in the interest of time, to deal with this incredibly shortly. It is obviously fundamental to the Secretary of State's case and to the reasoning of both courts below. The reason I'm dealing with it shortly, subject to the court's view, is that there doesn't appear to be any dispute about its applicability at all. It's expressly indicated on the face of the appellant's written case at paragraph 55 and 126C that the principle is accepted, that restriction needs to be imposed by condition. There's also a helpful survey of the authorities which apply "I'm your man" in paragraph 54 of the appellant's case. So there's the judgment of Miss Justice Hickenbotham in the Cotswold Garden case in the High Court. There's a divisional court authority, and it's considered in the Court of Appeal in Wall. Those three are referred to at paragraph 54. The only additional one that's worth bearing in mind is the Smoot case, which is a Court of Appeal case, tab 74. I don't propose to take it up, but I do refer to paragraph 20, where Lord Justice Laws applied "I'm your man" as part of the reasoning in that case, albeit in an environmental impact assessment context.
But the only oddity, as I suggested, was that the Secretary of State doesn't seem to have argued in that case that it was an implied condition based on that 1958 dictum of Parker.
Yes.
Parker.
No, it wasn't, because I'd respectfully submit the prevailing position was that until the observations of this court in Trump, and in that context Obiter, the prevailing perceived wisdom at the time "I'm your man" was argued was that there was no such thing as an implied condition.
Even though the divisional court had thought there was.
Well, my lord's referring to Francis.
Yeah.
Well, in one case, in an obiter observation, in quite a different context, my lord. So
yes, I see. So things were sort of, Trump put a new complexion on all this.
Well,
as on so many things.
Well, I think that's almost certainly right as a matter of chronology, and obviously, we're part of the issues to be debated in these proceedings is the scope of the observations made in Trump, and whether they go to a fully implied condition. On our side, as you would have detected, we had read the observations to being not precluding that, subject to the great restraint comments.
Yes. Yeah.
There was a similarity between Francis and Newsley on the one hand and "I'm your man" on the other, as I understand it, in that in each case the question was as to the duration of the particular permission.
That I think is right. A difference was that in the Francis case it was a construction of a decision letter of the Secretary of State, and in the "I'm your man" case it was a local authority grant where it had been. I think that's right. I don't want to put that wrong. Actually,
I don't want to take you off course, but I didn't know if that's a material distinction.
I think that my primary submission in relation to Francis is that the observations are obiter, and that and in the particular context of the enforcement notice in that case, my submission is that "I'm your man" represents the orthodox position. At the time "I'm your man" was considered, it wasn't an orthodox position that there was such a creature as an implied condition, and I respectfully submit that the observations of this court in Trump were really the turning point of that being a potentially credible argument to be considered, with the prevailing position at the time of "I'm your man" being that wasn't featuring in the argument. I accept it wasn't argued in those terms, that there were arguments advanced that there was an implied limitation, and that was rejected on the basis of the statutory scheme because restrictions had to be by condition. I accept that that leaves unanswered the question of an implied condition, but I respectfully disagree with the proposition advanced in my learned friend's written case that, if you like, the evolution of the possibility of an implied condition is something that would affect the perspective of the reasonable reader looking at the condition in the context of the clear understanding that there needs to be an express limitation by condition if you are to remove the effect, in clear terms, if you are to remove the effect of the use classes order.
Thank you.
So, my lord and lady, I propose to move on to the substance of the argument in the time that I have left, and to deal with it in terms of the interpretation arguments, and then Chartbrook, and then implication. If I can start on the question of interpretation, I'd respectfully invite the court to go to paragraph 38 of the Court of Appeals judgment at MS 189 as a useful starting point. This is Lord Justice Lewison having cited the relevant authorities in terms of Marks and Spencer's impact funding solutions, so the most relevant authorities of the Supreme Court. And then I just invite attention to the way he puts the issue in the last sentence of 38. The objective of the exercise, that's the exercise of interpretation, is not to determine what the parties meant to do in the broad sense, but what a reasonable reader would understand by the language they in fact used. Now, if I can just observe that there is a tension that I respectfully suggest goes back to principles 4 and 5 as have been articulated by Lord Hoffman in the investors' compensation case, between those which has been playing out in this court, between those two elements. In other words, element 4 that is very much rooted in the language of the document to be construed, and element 5, which is the indication that the court will not sanction an uncommercial approach as a matter of interpretation when it doesn't have to. And I respectfully suggest that much of the debate in the cases might be reference to that. Now, the court here, I say rightly, is orientating the interpretation analysis in the language used, which is very much the emphasis that features in the most recent Supreme Court cases, in particular the judgments of Lord Neuberger in Arnold and Marks and Spencer's, to which I will make passing reference in my submissions. So, my lord, I say that's the correct. My lords and ladies, I say that's the correct formulation. It does differ. I respectfully observe from some of the formulations that my Lord Carnworth has put, because it's not just what they meant, it's what they meant as understood through the language which they used, and that is, I respectfully say, an important difference in this area. And that's...
Is it an important difference if nothing in the argument goes outside the four corners of the document? Which consists, after all, just of language.
Which is the so if it's a... I will respectfully say that both propositions need to be credible propositions based on both the language and the context. Now, if you are in the territory where on the face of the document you have two credible propositions that are there on the face of the document, and in the overall context they fall to be considered, then I respectfully would accept that would be, both of those would be matters of construction. What I don't accept is that it's possible to rewrite in a contractual context the bargain, or in this public law context the nature of the permission. And I was intending just to draw attention to two passages from the authorities to emphasise that. The first one, just very briefly, but the first one from the Belize decision of the Privy Council, which had in the authorities, there's obviously a discussion about the extent to which this takes an expansive approach to implied terms, and it's clarified that it doesn't, but it's occasionally was misperceived as an expansive approach to implication. But even in that context, Lord Hoffman starts his analysis at page 516, MS 516, paragraph 16, by making it absolutely clear the court has no power to improve upon the instrument which it's called upon to construe, whether it be a contract, statute or articles of association. And I submit that that is the right approach for the construction of a planning permission. If that planning permission is defective as a matter of construction, it is not the job of the court to improve it or rewrite it. And there are real problems with it doing so, both in terms of certainty, but also in terms of the actual exercise of the planning judgment as to which conditions ought to be imposed upon it. That limitation is also very clear, I would respectfully suggest, from paragraph 77 of the Arnold case, which is the judgment of Lord Hodge. And I'll return to this passage in a short while, but I go to it for the purpose of the limitations of the exercise not including rewriting. So this paragraph, which is MS 488, he's discussing the iterative process, so the extent to which interpretation implication Chartbrook is one exercise or differing exercise sequentially. And he says, This unitary exercise involves an iterative process by which each of the rival meanings is checked against the provisions of the contract and its commercial consequences are investigated, but there has to be a basis in the words used and the factual matrix for identifying a rival meaning. And that was what I was attempting to refer to in my answer to my Lord Briggs question. The rivals need to be credible both as a matter of language and as a matter of, I would respectfully say in the present position, context rather than factual matrix. So the context, which you'll see through the analysis of the Court of Appeal, includes the statutory context, including the I'm your man principle and how the reasonable reader would look at this, understanding section 73. Just continuing with with this paragraph, the role of the construct, the reasonable person, is to ascertain objectively and with the benefit of the relevant background knowledge the meaning of the words which the parties used. The construct is not there to rewrite the parties' agreement because it was unwise to gamble on future economic circumstances, a long-term contract, etc. So observations then that are germane to that case. But the proposition that's very much there is that it's not about rewriting the agreement. That's fundamental limitation on the approach to interpretation. Now, in the present case, I respectfully say the Court of Appeal were correct to approach the matter through that prism. There's no real dispute about the straightforward interpretation provisions as they apply to planning permission post-Trump. The appellant in their written case sets them out and then says that they were understood and applied by the Court of Appeal. Forgive me, that in paragraph 35, that the Court of Appeal understood the approach to interpretation and followed the approach that's set out. So what's required in following Lord Hodge in particular in Trump is to have a harmonised approach to interpretation, but to take account of the particular context, which is, for example, the limited role of shared knowledge, which is referred to in paragraph 33 of Lord Hodge in Trump, the public nature of the documents, the fact that criminal sanctions may attach to them, and the need for clarity and precision in the drafting of conditions. Those are matters that are expressly referred to by Lord Hodge in paragraph 33 of Trump. Now, my submission on behalf of the Secretary of State is that the Court of Appeal fully understood that context and brought together the relevant points of context for approaching the interpretation question, leaving aside Chartbrook, which was dealt with separately and which I will deal with separately because my learned friend puts his case on that on a slightly different basis. But I do draw attention to paragraph 52 of the Court of Appeal's judgment at MS 193, where I say the critical points of context are correctly and forcefully gathered together by the Court of Appeal. So the propositions being that the reasonable reader of the decision notice will be notionally equipped with some knowledge and understanding of planning law and practice, will understand the differences between permitted use and restrictions, will understand that a Section 73 application gives rise to a fresh planning application, a fresh planning permission on which the conditions must be expressly stated, and also to look at the planning history where the relevant basis on which express conditions were imposed was always actually about traffic concerns rather than any in-principle objection to the expansion of the use. And it's in that context that, as Lord Justice Lewison observes, the permission that is then granted doesn't contain any express restrictions and does contain conditions which are imposed on the face of it after considering development plan policies relating to traffic and on traffic grounds.
Would it be possible to look at the decision notice for a moment in a way which isn't permissible in the end, because we've got to bear Section 73 and its effect in mind, but just to put that to one side for a moment and see what you might otherwise make of it, just to see how pivotal Section 73 is in your argument?
Yes.
If we look at it that way, they've got it wrong because they think it's a variation of condition, but it looks, doesn't it, as if they are banking that condition but amending it.
From the by virtue of the approving...
Approve the following
the
application for the variation of condition, and then they set it out, and then they set out the way in which it would look if they approved the change that's been proposed. And it looks as if that's being banked, not jettisoned.
Well, my lady, I accept that, but to this extent. I say, consistent with the reasoning of the Court of Appeal, that what is being approved is the permitting of the site for the display of non-food goods only on that in this iteration where we're ignoring the score.
Yes, except that they call it condition. Now, I understand that's because it was a condition.
Yes.
But they're using the wording variation of condition, as if it continues to be a condition. That's what they think is happening. Yeah,
I see my lady's point. My submission is that the reading this as a whole, what is approved is on the hypothesis that we're looking at it on its own terms. What is approved is the proposed wording. The proposed wording is an expansion of what is permitted, and then the tailpiece. And my submission is that the expansion is there to expand the sale and display of non-food goods only. The Court of Appeal said the same thing at paragraph 37, but I say, even in this hypothesis, the I'm your man issue is a significant problem there, because then the tailpiece there is not effectively imposed. We're in I'm your man territory. It's like it said, for a limited period only. Interesting, but not effective. So, my lady, I do submit for that reason, even if my respectful submission is my argument isn't entirely pivotal on Section 73. It is wholly informed by the nature of Section 73 and the I'm your man, but on the hypothesis that I understand my lady's putting to me, I respectfully say there's a very important I'm your man problem, which is quite independent of the Section 73 issue.
Can I ask you about the conditions? It's something I probably have this in front of us. It's something I touched on earlier. The inspector was asked to consider condition 1, and she approached it on the basis that the development in question was the development of the erection of the building.
Yes, is it the retention of the building?
Yeah, and plainly, on that construction, the conditions are nonsense.
Yes.
And so the condition had to be struck down if that's how it is going to be read. On the other hand, it seems very to me pretty clear that what Lambeth meant by the development was a variation of the condition, and if that were the reading, then the condition at least wouldn't be nonsensical. If we come on to condition 3, and condition 2 isn't affected, but condition 3, within 12 months of the implementation of the development hereby approved. Now, presumably on the inspector's reading and your reading, that's within 12 months of the building going up.
Well, I'd respectfully suggest it's the retention of the building for the varied use.
Isn't the development the change of use is an odd way to put it, but it's a use untrammelled by the previous more restrictive condition.
So the change of use is a term of art.
Yes, which this isn't because it's within the use classes.
Yes, but it's as distinct from the erection of operational development. So it's where there's no. The classic case would be where it's a use which is in itself, irrespective of operational development, is so material that it would amount to development.
There's a problem about Section 73, because in condition 2, it's described as prior to the variation hereby approved being implemented.
Yes.
I suspect that's what they thought they were talking about when they talked about the development.
Yes,
but
I think so.
We've got to face up to the fact that the language of this doesn't quite fit 73.
Yeah, but as I was going to come on to, that's really the point I was
Oh, sorry.
going to develop in relation to 3. But this is all to do with a traffic survey being done within a short time of the implementation of the development hereby approved, and then the idea is then to compare the traffic actually being generated with what had been predicted in the transport assessment submitted with the planning application, and then in light of that, there's going to have to be mitigation measures if agreed with the council and implemented if the junction capacity is worse than was predicted. Now, this all, again, I presume, is intended to relate to the implementation of the varied condition. In other words, the expansion of the use to encompass a wider range of goods.
A wider range of goods, begging the question, how wide?
Yeah. So again, for this condition to make any sense at all, you have to understand the development hereby approved as referring to the variation of the condition.
But that which technically is not.
I know it's technically
is not.
Technically, it's completely wrong.
Yes.
But I mean, this is like Mrs. Malaprop's allegory by the banks of the Nile. I mean, this is a planning officer who apparently isn't using planning language in its technically correct sense.
Yes. My Lord, I see the force of those observations. The issue that comes before this court is in a context, I think, where there's evidence that those conditions 2 and 3 have been discharged. And the issue that arises is obviously from the certificate of lawfulness.
Well, I appreciate that, but one has to construe the document as a whole.
Yes.
And that's really that's the only reason I'm looking at these conditions.
No, my Lord, I fully understand why my Lord is. My submission is that, well, in a sense that condition 2 and 3 may be cut both ways to an extent. One element that I do positively rely on as part of my case is that there is an indication here that these are measures that are being imposed as a matter of planning judgment to deal with a potential highway concern. Now, there is no evidence that the potential highway concern is a shift in highway from DIY to non-food, as distinct from DIY to some wider indication. We don't have any. So we have to look at this on the face of the permission, and we had previous restrictions that were imposed on highway grounds. Here we have no restriction that's said to be the effect of this imposed through a condition, and two conditions that on their face deal with it. Now, my lord...
I mean, surely it's obvious that what they're trying to do is to face up to the difference between the original wording and the proposed wording and the traffic effects of that. I mean, if you look at the document as it stands, they may not describe it very aptly, but that's surely the only way you can sensibly interpret it.
Well, my lord, in other cases, in other contexts, my lord has observed about the absence of evidence to assist and points like that. I'm
not talking about evidence.
Well, I'm submitting that my lord should be thinking in terms of evidence for points like that, because my lord's putting to me it's obvious that it's all about the transport differences between DIY and non-food retail, and my submission is that that's an inference too far for the court to draw, because there's no evidence of that.
No, but why is that not the obvious effect of change and approval of a revised wording of a condition, one of which, I mean, that's the effect of the change?
Well,
it doesn't get the other side home, but I mean, simply if one's looking at this, what they're trying to understand what this means, that I would have thought was pretty obvious.
Well, I respectfully accept it's pretty obvious that it's defective in terms of Section 73. I do come back to, in order to make this workable and certain and to have clarity, I respectfully say that the question raised by this application is where is the restriction in this permission by way of a condition to take away that which the developer would otherwise be entitled to.
Well, you say making it workable, and obviously making it workable is important. It's a basic canon of construction. Ut res magis valeat quam pereat. But the reading you're proposing renders 2 out of the 3 conditions invalid and
Well, my respectful submission is the reason that they're not, the reason they might not be effective isn't, well, I respect it's not my reading, it's the objective language that is used by the confusion as to what actually the legal effect of this document is through, if you like, taking the shorthand of variation of a condition and imposing it rather than using the mechanism that the statutory framework sets out. So,
it's consistent. The whole document is framed as if the variation of a condition constituted development. And that's really the key to reading this whole document.
But that is a legally flawed.
It's not in order to make the time-based structure of these conditions, and that applies to all 3 of them, work. Has one not got to read the phrase development to which this permission relates and the variation hereby approved being implemented and the implementation of the development hereby approved as meaning the expanded use hereby rendered lawful? And it's rendered lawful not by the permission for development, because that was all within the use class order anyway, but by the relaxation of a condition.
I see the force of the point my lord's making. My answer to it is that's the one has to distinguish on that view between what is authorised and what is restricted. And I say it's consistent with the Court of Appeal that the expansion of the use is authorised, but there is no effective restriction imposed. And that's...
Well, I entirely accept that that making sense of these conditions isn't quite the same exercise as asking whether there is the additional restriction.
Yes.
But at least if one reads those phrases in the way I've suggested, it makes sense just of these conditions. It helps you understand when they kick in.
Yes.
And if that's so, and one understands, therefore, that the man who, or the person who was drafting this, is actually thinking in terms of an expanded use rendered lawful by a relaxation of condition, then the question is whether that throws you back to a reconsideration of the meaning of the earlier language.
Yes, and whether and I would say, and whether or not there is an effective, whether or not that whether or not that is effective, whether or not that may be what was intended, but what was intended is legally defective. And the points my Lord's making are an attempt to are potentially capable of being deployed in an attempt to make sense of a document, but actually the overarching consideration may be that the form is wrong, the basis of this is wrong, the conditions don't actually add anything to the central question for present purposes, because they actually beg the critical issue as to what precisely it is that has been authorised and effectively restricted. So my Lord, I do see the force of the analysis that is based on linked into to the observations my Lord Reid made, but I do stick to the proposition that one needs to find that clear restriction, and that the mere fact that condition 2 and 3 might not make sense as they are drafted does not actually help one to find the restriction that's missing, that's the central issue in the application that gives rise to these proceedings.
I can't at the moment quite lay my hands on the allegory by the banks of the Nile, but I have found Mrs. Malaprop in the ICS case at page 732, and the way Lord Hoffman put it is that many people, including Mrs. Malaprop, mangle meanings, but nevertheless communicate tolerably clearly what they're using the words to mean. And that might be said of this planning officer.
My Lord, help me where that is on 732.
It's 732, just below F.
Just below F. My submission is that the court should be considerably more benevolent in the contractual context than in the planning context, because of the need for certainty and precision. And whilst we're on that page, that's where, if you like, I respectfully say there are tensions between point 4 and point 5, which I will say are resolved in subsequent cases quite strongly in favour of giving legal effect to the words that are used. And I respectfully say that the discussion that we're having is a fundamental rewriting of the words that are being used.
Well, as to that, you see, on the facing page, he refers to Lord Justice Leggett's comparison of the argument with Alice Through the Looking Glass below E, and says that Alice and Humpty Dumpty were agreed that the word glory didn't mean a nice knockdown argument. Anyone with a dictionary could see that. Humpty Dumpty's point was that a nice knockdown argument was what he meant by using the word glory. Once he'd told her, or if without being expressly told she could have inferred it, she would have had no difficulty in understanding what he meant. So, I mean, anyone with a planning dictionary could tell you that development isn't the same as a variation of a condition, but nonetheless it may be tolerably clear that that's what the phrase means in this document.
Well, my Lord, I would strongly caution against that as the right approach in this particular context, because what that will mean is that the mechanism of the statute under Section 73 will effectively not be applied in a way that's easy to read. And I started my submissions by looking at the facts, by showing how the inspector had found it very easy to formulate and answer the question where in this permission is there the taking away of that which there would otherwise be an entitlement to, and asking the established questions couldn't find an answer to that. The proposition that we're debating effectively will make it very, very fact-specific, very difficult in relation to a document where many people will need to rely on it. It's required to state clearly what the conditions are, what the reasons are, for those to be kept on the public register in the interests of clarity and precision. So I do say in this context, that sort of exercise is a bridge too far, because it necessarily involves I submit, a departure from the words used as correctly understood in their context, having regard to Section 73 and the I'm your man principle.
But where it leads to is that to make it work on your argument, you have to get a condition out of this document to the effect of restricting the use and not allowing food. You have to...
The court does, or the reasonable reader would.
Yes.
Yes.
But that's there, isn't it, in the very first paragraph? You can't approve a variation of a condition without leaving a condition there.
What, by virtue of the word variation?
Well, you can't, you can get rid of it, but if you vary it, then it's there.
I think one could vary a planning permission by removing a condition, which is actually the statutory exercise.
Yes.
You could vary by reducing 10 conditions to 9, although
Yes.
others would say you've just removed one condition.
I'd respectfully say, I understand the point my lady makes, and I understand as a matter of language, variation implies something is left behind.
I understand the other point, but if you follow it then through in the document, I think it shows you that it's the condition, this condition, remaining but being changed.
But that is all premised, I respectfully submit, upon using the shorthand for what the Section 73 application is, which is not consistent with the statutory scheme, not consistent with the IMU principle.
Can I just ask you about that? If you look at Section 73 as is, I'm looking at it on page 84.
Sorry, on page 84 of
Yes,
the
of electronic,
Yes.
where it's helpfully set out in
Yes.
someone's case, I think it's the appellant's case. Subsection 2 says that on a Section 73 application, I'm alliterating slightly, the local planning officer shall consider only the question of the conditions subject to which the planning permission should be granted. And I wonder if that means that the savvy, reasonable reader, who I think must be taken to understand Section 73, and the fact that it's under Section 73 is blasted across the top of the page of the decision notice, would approach the analysis on the first page going over to the second page of what this is for, and original wording and proposed wording, as all to do with conditions. Because the underlying concept is that the planning permission, which is there already, isn't changing. What's changing is the conditions to which it's subject.
But which are to be
Set-
contained within a freestanding planning permission that contains all.
I understand that point entirely, but my question to you is whether, in fact, Section 73 doesn't give a reasonable reader's, mean that the reasonable reader is looking at it through spectacles, where he is inherently assuming that what is changing is a change of conditions rather than anything else.
Well,
I quite accept that if you simply had 10 previous conditions reduced to 8 so that 2 disappear, that would be the change he would identify, but this document doesn't really work like that.
this document doesn't, but my submission is that the scheme, the reasonable reader understanding the statutory scheme would be looking at this document to say, what are the conditions left to which the planning permission is subjected? And I need to find those on this document. So my lord, I hope that helps.
Yes, I understand.
To answer the point. May I, I'm conscious of time, may I just complete, my submission on interpretation is that paragraph 52 correctly imputes a correct understanding to the reasonable reader, and that the appellant's submissions to the contrary, that there's some artificial division, are fundamentally inconsistent with the statutory scheme and the I'm your man principle, because the distinction between restriction by condition is fundamental to the statutory scheme. On the chart, Brooke, may I just very briefly, my submissions are that the Court of Appeal was right in the approach that it made, in particular paragraphs 53 and 56. I say that that they were right to observe in paragraph 53 that adding a whole condition has a fundamentally different effect to the words that Lambeth in fact used, and that is a correct observation. In terms of approach to Chartbrook, at paragraph 23 of Chartbrook itself, Lord Hoffman makes clear that it's not a separate branch of the law, and my learned friend referred correctly to the approach which is apparent on the face of Chartbrook itself at paragraph 20 in the Pink Floyd case, paragraph 20 of tab 20, that the outcome for a chart book corrective interpretation must be arbitrary or irrational. I had understood my learned friend to accept in answer to the court that the permission made sense without the interpretation that he seeks to rely. In other words, it is a document that works if it doesn't remove the use classes order. Now, I say, on a correct understanding of the law, that's actually a concession that the Chartbrook test is not met. And may I just very briefly draw attention to the Arnold case, two passages I want to take the court to. Paragraph 17, so this is tab 1, MS 476, where Lord Neuberger observes, and I've alluded to this, I think, on a number of occasions, but Lord Neuberger observes, reliance placed in some cases on commercial common sense and surrounding circumstances, for example in Chartbrook, should not be invoked to undervalue the importance of the language of the provision which is to be construed. And then the exercise of interpreting a provision involves identifying what the parties meant through the eyes of the reasonable reader, and save perhaps in a very unusual case, that meaning is most obviously to be gleaned from the language of the provision. I therefore do submit, if we go to the passage I've already alighted on in paragraph 77 of Lord Hodges' reasoning, that a judgment where he formulated the idea of an iterative process looking at the testing the various hypotheses against the words used and the factual matrix. I've already indicated my submission that factual matrix includes the relevant background considerations drawn together in paragraph 52 of the Court Appeal's judgment. So I say the construction advanced by the Secretary of State that there's no condition effectively restricting the use classes order follows the words used, so it passes the first test, and is consistent with the factual matrix, the paragraph 52 of the Court of Appeal range of considerations. By contrast, the construction that there is an effective restriction of the use classes order, I say, involves a rewriting of the words that goes against the limits of Chartbrook articulated by Lord Neuberger in paragraph 17 of Arnold. And I do submit that the discussion that was instigated by the court shows the extent of the, I submit, rewriting that would be necessary to give force to that interpretation. I also say it doesn't fit with the context. Critically, two critical points of context it doesn't fit with is a proper understanding of section 73 and the uncontentious I'm your man restrictions. So I submit that the Chartbrook analysis fails on both limbs of paragraph 77 of Arnold. And I do, finally, on Chartbrook, and I'll deal with implication incredibly quickly because I'm conscious that I'm on borrowed time, but I also submit that the absence of a reason is also a further factor, because as my Lady Black, I think, observed, or is apparent from the discussion, by definition, you can't borrow the reason from that which is varied because it's not the same. So there is, on the face of it, no reason for the condition imposed. That is a statutory requirement. I go no further than to say that Lord Justice Lewison was right to articulate that as a further barrier to the Chartbrook analysis that arises out of this specific statutory scheme. And even if the reason is apparent on the face of the permission, and I submit it isn't, because there's mixed messages about what it is that's restricted for highway grounds on the face of this condition, but that would be a breach of a statutory duty, which would not necessarily be fatal in itself, but the reasoning of Lord Justice Lewison wasn't that this was fatal, but this was a further barrier that would need to be overcome. So I respectfully say in this context, that's a further indication of the need for caution in a Chartbrook analysis. In terms of implication, if I could deal with it very shortly, there is obviously an issue which my learned friend Mr Lockhart Mummery is going to address the court on the meaning of the observations in the Trump case from the court that are obiter about whether or not there could be an implied condition. The Secretary of State has understood the observations in paragraph 36 and 60 of that to not rule out the possibility of implying a whole condition, but to emphasise, as it was put by Lord Hodge in particular, the need for great restraint, and my Lord Carnworth speaks of a relatively cautious approach because of certainty and criminal sanctions. I say, on implication, the Court of Appeal was right to say there would need to be some modifications to the contractual test to take account of how you apply those and those very strong caution. And I also say they were absolutely right to indicate that the tests of business efficacy and so obvious it went without saying were not met, essentially for the reasons that were given in paragraphs 68, 69, 70 to 71. If I can just embark very shortly on the Marks and Spencer case at tab.
I mean, on Trump, you suggested it was something of a sea change of what was thought to be the position beforehand.
Yes.
And on the basis of I'm your man. But you're not suggesting that our Obiter remarks were wrong.
The Secretary of State doesn't in these proceedings challenge the possibility that in an appropriate case it might be possible to imply a condition, but it does very strongly emphasise that if that's not going to upset the statutory scheme, then very considerable caution would need to be applied for the reasons articulated in 35 of Lord Hodge and echoed in 66 of my Lord's judgment.
Thank you.
It would be, we respectfully say, a rare beast. In Marks and Spencer's, I would just draw attention to the question at the tail end of paragraph 21 on MS767, the way that Lord Sumption, Justice of the Supreme Court, articulated the point in argument. Term can only be applied if without the term the contract would lack commercial or practical coherence. And again, I say the court's right to say that's not the case here. And I also draw attention to my learned friend's acceptance that this is a permission that would work, albeit that he says it's the wrong one. So I say that proves that even on the contractual test, he's on the wrong side of the line there. And I like myself the observations of Lord Justice Lewison in terms of not being so obvious, because in particular there are conditions on the face of that permission and the highway factors are pulling in both directions in a way that wouldn't pass the test of it being so obvious that it went without saying. So, my Lords, I apologise I've had to canter through the implication of it. I'm finally, in closing on behalf of the Secretary of State, I do say that the idea of recourse in this case to either a proactive corrective interpretation or reliance on the implication would cause some difficulties. We would respectfully submit to the workability and certainty of the system, and that's very much at the heart of the Secretary of State's concerns. I readily accept that it's a difficult permission to be construed, but I would invite the court to ask the questions that I have emphasised in terms of where is the clear restriction on the face of this document, and if that cannot be answered through the orthodox interpretations of contractual principle, which I submit it can't, then great restraint should be followed, I would respectfully say, given the public nature of this, the need for certainty, all the reasons articulated in paragraph 35 of Trump militate against an approach of judicial activism that provides an answer to the facts of this case that may appeal to the court, but I would respectfully say will cause difficulties in terms of the understanding and implementation of this across the system. Unless I can assist further, those are my submissions.
Yes.
Paragraph 53, Court of Appeal, page 194. Lord Justice Lewison said, this is not a question of rearranging words that appear on the face of the instrument. The appellant's submission to us is, well, it can be done by rearranging the words if you either move the proposed wording down into the conditions section or add the word below to above.
Yes.
Do you want to say anything about that?
I'd attempted to answer that by drawing attention to the end of paragraph 53, where the reason that is given, that it's not just about rearranging, is that it's basically the effect of that is to add a whole new condition, which has a completely different test. So I would say it is fundamentally different from the idea of the syntax correction in Chartbrook itself, or one or two ways of reading it. It would be like taking a term that wasn't a condition precedent or something in a contract and making it a condition precedent. It would be redoing the bargain. So I say that the Court of Appeal are right to make the second part of that paragraph is the reason why the first part is a correct observation.
Thank you.
Thank you very much, Mr. Kalinsky. Ms. Blackmore, do you have anything to add? Yes, Mr. Lockett-Mummery.
My lords, my lady, can I start by asking you to retrieve our statement of case? In the core volume, tab 7. And I have one minor point of housekeeping just to deal with. It's really actually down to Lambeth, I think, this housekeeping. But if you kindly turn to page 2, internal page 2, MS page 154 of our statement of case, you'll see in our opening remarks the need for clarity and unequivocal conditions to exclude the effect of the use classes order, a run of cases starting with City of London and going through the Court of Appeal in Dunoon. We give a reference to Dunoon, my lord, in footnote 4, tab 9, and I regret that somebody the printers put in the wrong version, and we are going to circulate, if I may, because that's the High Court, and it should have been the Court of Appeal, as the reference given makes clear. And can I supplement your papers by inserting that in?
Yes, thank you very much.
Very much. I'm sorry for that. Well, while that's being done, I am going to address,
Thank you.
I think, some 8 topics, all fairly brief, knowing that the court has read our statement of case. And I'm going to start first with an emphasis on our starting point in the statement of case, which is the public interest nature of the statutory scheme set on one side against private law commercial concepts on the other side, for which purpose, of course, if you go to page 3 of our statement of case, MS 155, the bedrock of that is the famous dictum of Lord Scarman in Pioneer Aggregates. And I know the court has read this, but may I just take 2 minutes just emphasising his lordship saying planning control is a creature of statute, imposition in the public interest of restrictions upon rights of land, and a reference to Newbury. Dropping down under Newbury, it's a field of law in which the court should not introduce principles or rules derived from private law unless it be expressly authorised by Parliament or necessary in order to give effect to the purposes of the legislation. Not the purposes of the parties, if I may add, my lord, but the purposes of the legislation. Planning law is based on land law. Where the code is silent or ambiguous, resort to the principles of the private law, especially property and contract law, may be necessary so that the court may resolve difficulties by application of common law or equitable principles. Well, again, Lord, breaking off, that's introduced by the supposition that where the code is silent or unambiguous. The code is not silent or ambiguous in the present circumstances. It contains the statutory provision set out in the cases, not least as to the circumstances in which planning conditions can be imposed and how they can be imposed. I carry on in the last line of that page, but such cases, that's where the code is silent or ambiguous, will be exceptional. And if the statute law covers the situation, it will be an impermissible exercise of the judicial function to go beyond the statutory provision by applying such principles merely because they may appear to achieve a fairer solution to the problem being considered. And my lords, I say fairly and squarely, as we have said in writing, and I say it now, that in our submission, the appellant's case is squarely in conflict with that authoritative statement of the planning law. I want to develop that just in this way, if I may. The public nature of the statutory scheme derives from the intervention of the 1947 Act, of course, when development values were nationalised, and there was a system introduced by the Attlee government based on the development plan. And the sections with which we are concerned, well, or let's say sections 70, 72, 73 essentially, are within Part 3 of the 1990 Act. It's not, of course, accidental that that follows Part 2, which is now repealed and in the 2004 Act, as the Court may know. Part 2 of the Act in its original form was entitled Development Plans. And, my lord and lady, I don't want to go too far on territory that you may be well familiar with, but development plans were formulated having regard to surveys of the population in the area, the needs of that population, social, economic, and so forth, housing, exposed to public examination and then approved. The development plan then becomes at the heart of the development control system. So it is that when we get in the authorities, volume 2, tab 33, to the sections with which we are directly concerned, and we go to page 1118, which is section 73, which of course is the central focus of this appeal. Certainly I would invite that it be the central focus. We know that an application under section 73 is an application for planning permission. The Court of Appeal in Pargen, as Mr. Kalinsky rightly referred to, adopting and approving Mr. Justice Sullivan in Pye, therefore told us clearly that the provisions of section 70 were engaged by an application for planning permission. And if you go kindly to page 1110, this is engaged in a section 73 application, but is the general considerations. 1A, they may grant planning permission either unconditionally or subject to such conditions as they think fit. I will return to that little point in a moment. 2, in dealing with an application for planning permission, the authority shall have regard to the provisions of the development plan so far as material to the application. And that requirement to have regard to the development plan permeates a range of other powers and duties in the Act, not only planning permissions, but revocation, the service of enforcement notices, and so forth. Pausing there, if I may, and going to the planning permission in the 2014 permission. Hence it is that the development plan was so at the front of the Council's consideration of this application. Summary of reasons for granting planning permission. In deciding to grant planning permission, the Council has had regard to the relevant policies of the development plan. They then set out, and I won't read it, the slightly complicated circumstances where there are 2 extant development plans. And I drop down, if I may, to 2.5 lines from the end. Having weighed the merits of the proposal in the context of these issues, it is considered that planning permission should be granted subject to the conditions listed below. In reaching this decision, the following policies were relevant. And we have policies from the core strategy, part of the adopted development plan, including transport. We have policies from certain what are called saved policies of the UDP, which are, as you see, transport and parking policies. And so it was those policies that were relevant to the decision to grant planning permission subject to the conditions listed below, and therefore we can be confident that the conditions listed below, and we can forget about condition 1 for the time being, indeed we can forget about condition 1 entirely, it's been held to be invalid. We can be confident that it was those policies listed above that informed the planning authority's discretion to impose a parking condition, condition 2, and a traffic monitoring condition, condition 3. And that way of looking at this permission, I'll come back obviously to section 73 points, is a proper application of the statute to produce, as it were, a detailed result in the light of the development plan. Second topic, my lord and lady.
Well, just before we leave that, what is the, on your approach, we know from section 73 that the principle of planning permission is not to be considered. The only issue is conditions. When they say in deciding to grant planning permission, the council has had regard, etc., etc., what is the development for which they're deciding to grant planning permission?
My lord, there is no development within the meaning of the Act. That was a point that was raised in the original ground 3 of the challenge, which related to condition 1, which provided that the development to which this permission relates must be begun not later than the expiration of 3 years, beginning with the date of this decision notice. And both the High Court and the Court of Appeal accepted submissions that certainly I made. I forget entirely the position of the Secretary of State. The development here, the only development that took place was the original construction of the store back in 1985 pursuant to that permission. The change in the range of permitted goods is not development, and if there were any doubt about that, of course, the use classes order dispels that, because it deems a change in the range of goods to be not development. Mm-hmm. Hence it is that the terms of this permission in this respect, as in others, are not entirely perfect, of course. Condition 2 makes more sense in terms of the strict application of the words of the statute prior to the variation hereby approved being implemented. And the variation hereby approved being implemented are the new regime that results from the grant of this permission subject to conditions 2 and 3. And then, as I think Lord Briggs has suggested, and certainly my submission would be, that condition 3, within 12 months of the implementation of the development hereby approved, got to read that in the light of condition 2, it's within 12 months of the implementation of the unrestricted range of goods.
The trouble is,
there's no other development.
The difficulty is with that reading of the variation hereby approved is that we know from the previous page that the hereby approved, the Lambeth hereby approves the following application for variation of condition as set out below, and we're told alongside the word for, variation of condition 1 to allow for the sale of a wider range of goods. So that seems to be the variation hereby approved.
Well, my lord, there is no doubt that this was a permission for non-food retailing in the body of the permission, as the Court of Appeal recognised. The issue, of course, is whether there was a condition which lawfully gave effect to the proposed wording.
Yeah.
That's been the issue throughout the case.
Can I just-
But I am going to come, forgive me, my lord, I am going to come to section 73 specifically, which of course has been at the heart of certain questions and
Thank you.
debate. My lord,
Sorry, maybe you're coming to this. I was just reminding myself that Section 73 was a bit of a newcomer. I can't remember, though it was introduced. I was just looking at what Justice Sullivan said about this, as reported in the Power Gen case,
yes,
where he talks about the background being basically to ensure that people were able to hang on to the benefit of the original permission. But he says, I mean, it's in the Power Gen case, I'm not sure where that comes, 717 of the MS. And there's quite a useful account, which is adopted by Lord Justice Sheeman, of the background of what came in as Section 31A of some legislation. And you have that, it's page 1716.
I'm just getting there, my lord.
No.
I'm familiar with, indeed, I'm familiar. Yes, my lord is thinking, and of course this is what Mr. Justice Sullivan is addressing, that
Yes.
in the pre-Section 73 days, if you weren't happy with the permission, you had to appeal the permission.
You
And
might
of course
lose
the
your
result
permission.
of that might be you'd lose the baby with the bathwater. You might lose the whole permission. And so this was brought in as a means of focusing on just conditions.
But he says over the page, while Section 73 applications are commonly referred to as applications to amend the conditions attached to a planning permission, a decision under Section 73(2) leaves the original planning permission intact.
Yeah.
That's the whole point. So you
Absolutely.
don't risk, as you say, throwing out the
Absolutely.
baby with the bathwater.
Absolutely.
But I mean, it's not that surprising that it's being referred to here as a variation, because that seems to be the way people thought about it.
And still do.
Yeah.
And I mean, we've seen it today, and one sees it constantly. I'm applying under Section 73 to vary my noise condition or whatever.
And so when they're talking about the development hereby permitted, again, what we thought is not surprising if they're thinking of the variation hereby permitted.
Yes. Yeah. Lord, my second topic is just a brief reference to the statutory and public interest duties in relation to conditions specifically. And if I can go back to the Authorities Volume 2, please, tab 35, page 1110, as we were a moment ago, and I touched on this. 1A, they may grant planning permission either unconditionally or subject to such conditions as they think fit. So they've got to think fit before they impose any conditions of whatever nature. And then 2, in dealing with an application, the authority shall have regard to the provisions of the development plan so far as material to the application. That relates, obviously, in the word dealing, relates both to whether or not to grant permission, but also whether or not to impose conditions and what those conditions might be. And I've already referred to the summary of reasons as an example of this being implemented. Section 72, page 1116, subsection 1, without prejudice to the generality of 70, conditions may be imposed on the grant of planning permission under the section for regulating the development or use of any land. I'm going to take it shortly. Line 3, so far as appears to the local planning authority to be expedient for the purposes of or in connection with the development. So they've got to consider both the development plan and material considerations. They've got to consider whether any condition appears to them to be expedient. And they have got, of course, to impose, to provide their full reasons, full reasons for any condition that they do impose. And, my Lord, it's my submission under this second heading that the court is being asked by the appeal to bypass these statutory duties and discretions by applying tools of private commercial law, which of course have no such constraints. Indeed, Lambeth cannot and do not contend that their wished-for condition was as a result of the application of these statutory duties. My topic 3 is completely different and is dealt with in our statement of case, and indeed the provisions are referred to in those of my friends. And I'm going back, please, to volume 2 of the authorities, tab 33 again, page 1134. As you'll have gathered from our case, the essential submission to which these points are relevant is that Parliament has intervened to the extent obviously that it has prescribed as to where alterations to planning permissions may be made. And there are two. The first is section 96A, introduced relatively recently, a power in the LPA, Local Planning Authority, to make non-material changes to planning permission, and they may make such changes, subsection 1, if they're satisfied that the change is not material, and then subsection 2 indicates what they must take into account. And 3, the power conferred by subsection 1 includes power to make a change to a planning permission to impose new conditions or to remove or alter existing conditions. Now, I do not say that if we were dealing with a change in the planning conditions affecting a store from non-food to food, I can imagine a planning authority would say that goes beyond non-material. I think that's the likelihood. So I'm not saying it applies here. My point is a quite different one as to where Parliament has chosen to allow for changes.
That came in when? 2014, is it?
I think it's inserted by the Planning Act 2008 and date in force 1st October 2009.
Okay, thank you.
Yes. Well, the second power came in 2004 and is in tab 34. And it's a procedure for correcting what are called correctable errors. Page 1172, it's sections 56 to 59 of the Planning and Compulsory Purchase Act 2004, and relates to appeal decisions or call-in decisions. It doesn't relate to local authority decisions, because it says under 1, this section applies if the Secretary of State or an inspector issues a decision document which contains a correctable error. A correctable error is defined in section 59.5 at page 1178. A correctable error is an error which is contained in any part of the decision document which records the decision, but which is not part of any reasons given for the decision. Now, that power could plainly include the addition or alteration of a condition.
So this is section 56 of what?
2004 Act, my Lord, Planning Compulsory Purchase Act 2004. So, for example, my Lord, and this happens, I have seen it happen on more than one occasion, you have, for example, at an inquiry or a hearing, you have a condition or a whole raft of conditions being debated in evidence at the inquiry, and there will be a session by the inspector on conditions and so forth. And let us say there was, it was common ground that there should be a noise condition, and it was common ground what the noise condition should say. It should say no more than 55 dB or something like that. And in all the work that the inspector has to do, he simply forgets. When he comes to the end of the document headed conditions, he simply forgets to incorporate that condition. Or he does impose the condition but gets the number plainly wrong. That would be a correctable error. And so again, my submission is that one sees the scope where Parliament has chosen to step in to correct errors in or alter planning permissions.
Was that to deal with I'm your man? I mean, that was exactly what happened there, wasn't it?
Yes, my Lord, but it wasn't. I don't think it wasn't a response to I'm your man. It was a response to the sort of thing that I've been debating. That's to say, you do get plain errors, innocent errors in appeal decisions, and
Okay.
Of course, what had to happen, absent these provisions, was that somebody had to quash the permission.
What does a local authority, I mean, it doesn't apply to local authorities, what do they do? Do you agree that they could apply to quash their own decision?
They could apply to quash their own decision, yes, I do. They could revoke it.
Well, they'd
Modify, had to pay compensation, but my Lord, these are the statutory powers available.
No, you accept that they could apply for judicial review to quash their own permission?
Yes, I don't say that it would have been open in this case, but as a matter of principle, there is a well-established authority up to the Court of Appeal that the mayor or somebody can take proceedings against his own authority to quash a planning permission.
And why would it not apply? I mean, assuming you're right on the construction of this document, there was clearly made a mistake. They didn't take it.
Well, Lord, I don't accept the premise, but for a moment, but if
Assuming they made a mistake.
assuming they made a mistake,
Yeah.
an application for judicial review would lie.
Thank you.
How it would fare on the merits, of course, is speculation, but an application for judicial review would lie.
Thank you.
And my Lord, my simple point under this third topic is obvious that the court, in my respectful submission, should not create a further power outside the prescription of the statute. Can I come in my fourth topic to section 73 and go back, and I hope you'll forgive me if we're going over ground that by now the court is familiar with, but this provision, it's tab 33, page 1118, section 73. Manifestly, it does not provide that the authority may only, quote, vary, if I can use the colloquial term, the condition which was the subject of the application. The power is to consider granting permission subject to conditions, in the plural, differing from the original permission. And so what are the options open to the authority? They could, can I just contemplate four options? There may be more. Firstly, they could decide that the original goods condition in this case should remain by reimposing it. They'd have to reimpose it on this new planning permission. But equally decide, or also decide, to impose different conditions. That is a 2A case, which would be a grant.
I'm sorry, on the first possibility, would they not simply refuse the application?
No, my lord, they couldn't, because they're
2B.
imposing different conditions.
Oh, I'm sorry. I thought
On my supposition,
the supposition was that they were reimposing the same conditions
No.
in relation to
reimposing the original DIY
Yeah.
condition, let
Yeah.
us say, but impose different conditions
Right.
as well.
Okay.
And that would be a 2A case, and therefore they would grant. They could impose secondly, they could impose I use the term in quotes, a varied goods condition, different goods condition, and that would also be a 2A case of grant. Third, they could decide not to reimpose any goods condition but to impose other conditions. Again, another 2A case, and I just emphasise what the paragraph says. If they're doing that, they shall grant planning permission accordingly. So it's a power and a power only to grant planning permission subject to conditions. And of course, that is what we say is what happened in the present case. We say that what happened in the present case is expressly within the lawful range of responses of the authority. I respectfully would reject completely the approach canvassed by Mr. Reid orally and in writing, and that would be what's happening here was a substantial alteration and engaging the sort of Wheatcroft principles. It isn't. It's simply the exercise of a lawful response under this unusual section. So the fact that the applicant may or may not get a beneficial result is neither here nor there in terms of the statute if lawful conditions are imposed. And of course the fourth response is that the authority could refuse to alter the condition applied for, the sale of goods condition, and impose no differing conditions. In other words, they would impose under this hypothesis the original DIY condition. They'd impose no other conditions, and in other words, that's a refusal. It's a 2B case. And you will note that the 2014 permission, this is perhaps in parentheses, but the 2014 permission did not reimpose the conditions of the 2010 permission. There was a condition relating to refuse and there were various other conditions. This authority imposed such conditions as it thought appropriate for, as it were, 2014 onwards in this new permission.
Oh, which, are we talking about page 261, the conditions which weren't reimposed?
I'm looking, lady, I hope I haven't got the wrong reference. I'm looking at page, tab 8 of the core volume, page 434.
Yeah. Sorry, it's 261.
Oh, I see, I
the
beg your
paper
pardon.
copy,
Yes,
sorry.
I'm
So we
looking-
are looking there. But they were irrelevant, 2 and 3 by then, weren't they? Because they were conditions which applied prior to first commencement of any additional retail uses.
Oh, yes, but refuse and recycling
Yes, but they had to
goes
to-
on.
Yes, but they had to put
That's right.
the details in.
Yes.
Oh, I
and
see.
then
So
they
you're
should be
saying it's the
provided
second sentence. I
and
see.
shall thereafter be
I've got it.
retained. So
Yep.
obviously the refuse creating potential of the
I've got it.
development goes on forever.
No, that's fine.
And so what I'm saying, my lady, is that here is an exercise of a discretion that's different.
Yeah, and equally
Yeah.
three in relation to, I mean, one of the most important aspects of these developments is deliveries.
Yeah.
Yes. So they've decided, I have no idea why, but that's in their discretion. They've decided that conditions 2 and 3 of the new regime are sufficient as being expedient, having regard to the development plan and the public interest.
Or they haven't, and they've just assumed that these have carried on.
Yeah.
Because, as you say, these are central features which have a continuing application.
My lady, whether the council made an omission in this respect, I don't know.
But it takes us back to the whole question of variation of condition. They think they are engaged in just varying condition 1. And in the course of this short decision notice, it mutates from that. And then when you get to summary of the reasons, it becomes for granting planning permission. And then within half a page, it's mutated back to the question of approval of a variation. So the bit which is out of place is actually the reasons for granting planning permission, the words planning permission. I know it's entirely consistent with section 73.
Well, my lady, this document has got to be construed as a whole, and when construed as a whole, in my submission, it makes perfect sense to reach the result that the Secretary of State and we propose.
Whilst I've made you pause, can you help me with something else that's been puzzling me? And that is when it sets out on the document 4 what they're seeking. 441 of the... it says 4, variation of condition 1. And then it goes through, I think, the 2010 variation of the permission which was granted in 1985, doesn't it?
It repeats, I think, the wording under 4 and original wording are the 2010 range of goods.
But the original wording ought, on that basis, to relate to, I think that's 6 as the original 1985 permission, isn't it?
My lady, not quite, unless I've...
Well, there's the words which come and go are including the retail sale of food and drink.
Lady, if you look at either of these sections of text and get down to builders, merchants, goods, do you see in line 4, everything that the 1985 condition stopped there.
Well, except it went on to say, and for no other purpose.
Sorry, in terms of the permitted goods.
Oh, yes.
And so the 2010 permission also allowed everything from carpets down to office supplies.
Yes, but it had some extra words in, including in brackets, including the retail sale of food and drink or any other purpose. And they reappear when it says original wording. I just don't quite understand where these bits have been taken from.
Well, my lady, the 2010 permission was at pains to exclude the use classes order beyond the terms permitted, as it were, and emphasised, it didn't have to, but it did, and one sees this often, the particular wish to exclude the retail sale of food and drink.
Yes, I understand that. I just don't know where that there are two very similar passages, one at the end of variation of condition 1, which doesn't have the words in brackets in it, and then original wording, which is the next paragraph, which does have the words in brackets in it. Where has the one in variation of condition 1 come from?
I don't know, my lady.
Right, okay, well, it's not just me then.
I'm sorry to be slow.
Well, if I can-
I don't know.
Did you know?
Well, I think you find it on page 433.
433.
I got it on 434.
Yes. Yes,
And,
yes, I see that. Yes, I don't know what it's doing, but yes.
That's how it was described there. And then the actual condition in condition 1 includes the passage in parentheses.
Yeah, I see that. Okay. Thank you. Thank you.
While we're on to that, on page 442, the proposed wording doesn't refer to the use classes order, but refers to the GDO or the GPDO, is it?
It does.
Yeah.
Why is that?
It's a mistake.
It's a mistake, is it?
Yes.
I see. Thank you. But it has the same effect, does it? If it were,
I wouldn't. If I was, I would not myself take that point. If I were
that's
seeking
very helpful.
more flexible use, I think that would
I
be
thought I might have missed
a
something.
rather bold point to take.
Yes.
In the courts.
Righto, thank you.
My lords and ladies, can I now address my fifth topic? And I'm running out of time, and I'll do this very quickly. Intention. We approach, the courts approach intention by reference to the terms of the document which is being analysed, together with, certainly in the planning context, any admissible supporting or reference documentation. It's my submission that this permission, in the way that we view it, the Secretary of State views it, makes perfect sense as expressed within it, that is to say, the summary of reasons for granting permission and the development plan policies leading to the conditions listed below, and a car parking policy and a traffic monitoring policy that are consistent, entirely consistent with, as Mr. Kalinsky has taken us through, with the sole concern of the Planning Authority on 4 occasions, 1985, 2010, 2013 refusal, 2014 grant, all concerned with the impact of goods on traffic. And so the imposition of conditions 2 and 3 to control that matter are entirely consistent with an intention, an objective intention, which perfectly reflects the summary of reasons. Condition 3 works perfectly well, albeit that the transport assessment may have referred to non-food goods. It it's a perfectly feasible condition, because if the traffic generation is higher than predicted in that assessment, then there shall be revised traffic modelling submitted. And over the page, if that junction, if the modelling shows junction capacity is worse, then mitigation measures have got to be carried out. So if, as is likely, food use would create more traffic, condition 3 is there to mitigate any harm.
Sorry, I may have missed something.
That can't be.
You accept, I think, or do you, that the condition 3 from page 434, the strategy for management of deliveries, is still effective unless and until varied by the new condition 3?
I don't accept that, my lord.
You don't accept
No.
that? I missed that. So you say that the original strategy has gone.
I say this was a clean slate.
Yes.
And they thought the
you
conditions...
say also that the provisions for refuse recycling and things.
For whatever reason, I say that this was a clean slate.
Oh, I missed that.
It's not an extension of,
I understand what you're saying.
of the Reid, R-E-I-D case of importing conditions in a rather complex and uncertain way. I say this is a clean slate permission. And my lord, I would just like to pick up some observations that have been made in debate. That, for example, my Lord Cromer said that everyone agrees that they were trying to impose a condition, and a revised sale of goods condition was clearly intended. Now, I accept, of course, that what the individual parties, and there's only one relevant party, that's, say, the planning authority, is not the touchstone of this. The touchstone, as the courts have told us repeatedly, is, as I've accepted just now, the terms of the document itself read in a sensible way. But can I just point out, this permission was granted on the 7th of November 2014. Our certificate application came 7 months later on 10 June 2015. It was refused on the 12th of August 15, and the hearing took place on the 26th July 2016. My purpose in just setting out that brief chronology is that it would have been perfectly simple for the planning officer to state preparatory to or even at the hearing, I made a mistake. I intended to impose a non-food goods condition. But I made a mistake. I thought what I was doing was adequate, whatever it may be. There was no such evidence at the time. We are now 4 years after the certificate proceedings, and there's been no witness statement or anything to suggest that Lambeth intended to grant a restrictive sale of goods condition. And I submit that their silence throughout tells its own story. So easy for Lambeth to have dealt with this.
I mean, what if they had said we made a mistake, where would that have gotten?
Well, Lord, it would set the context. I do accept that in legal analysis it comes to an assessment of the document itself. But it would be, I respectfully suggest, a very bizarre result if the court accepted the appellant's case, which would achieve a result which, for all we know, they did not intend.
Do I take it that the food sales has not been implemented yet? It's waiting.
It hasn't been implemented.
And your interest, and I was intrigued by the fact that Nottinghamshire County Council
Yes, well,
was
not,
as an investor holding property in
that's right, my lord. The tenant is Homebase, and I don't know what the length of their lease is. Nottinghamshire County Council are the head leasehold owner, and as and when Homebase go, the value of the reversionary lease with a food permission is demonstrably more.
No, I mean, I'd assume that, but
That's the position.
but the fact that you're an authority makes no difference. It just happens to be.
No, it could be blogs. It could be blogs and co. It's yes, slightly confusing. I agree. Lord, my sixth point is Trump, and I make 2 points about Trump, if I may. The first is I do not accept that the dicta in Trump provide any support for the imposition of a whole condition, as opposed to providing teeth, if I can put it that way, within an existing condition. And our case at paragraph 32 sets out the passages in Trump where, in my submission, my Lord Conworth will have his own view about this, but those paragraphs are entirely dealing with the circumstances that were before the court then. And it's suggested by Mr. Reid that our case today is inconsistent with accepting the dicta in Trump insofar as they relate to implying teeth, if I can put it very shortly that way. Not at all. In Trump, let's assume that it wasn't, but let's assume it was a planning permission. By definition, the planning authority will have exercised all the statutory powers and discretion that I've drawn attention to. So they've complied with their statutory powers and duties. They've given a reason. They've simply omitted to impose teeth. My Lord, so far as CRISP is concerned, this is not an implication case, CRISP. Our statement of case at paragraph 33 sets that out. It was a construction case, both in the Divisional Court, Lord Goddard, and in the Court of Appeal. So, as I've said in paragraph 33 of our case, I respectfully suggest that Lord Conworth made an uncharacteristic error when saying that CRISP was a case of implication. It was a case of construction. So far as Francis is concerned, can I deal with that very briefly? And I'll deal with it just in this way. It's tab 10 of the primary authorities.
I'm afraid you are going to have to deal with it quite briefly because you're going to run out of time quite
My
shortly.
Lord, yes, I was given 55 minutes as opposed to an hour in the event, so, but I appreciate that that wasn't Mr. Reid's doing. So, I'll just make the reference. It's at page MS 687, it's tab 10. Lord Justice Parker, towards the bottom of the page, can I ask the court looks at this, the sentence starting about 8-10 lines from the bottom, for one reason, it seems to me, that the Minister had otherwise no power to give any such permission. That's with great respect to Lord Parker, most uncharacteristic error that. He refers to section 14 below. The Minister did have power to do what he did. He had power to grant permission without conditions, and that's what he did. So the premise of Lord Parker's remarks here, which in any event are obiter, proceed on a false assumption. Point 7, my Lord, we've referred to far-reaching consequences. And what I mean by far-reaching consequences is this. The effect of this court's judgment will not have implications just for planning permissions. There's a whole raft of other forms of consent in the Planning Acts which would be potentially affected. There are conditions attached to listed building consents, sections 16 and 17 of the Listed Buildings Act. There are conditions attached to tree preservation orders. If corrective interpretation or implication is a legitimate tool, then what about tinkering with confirmed enforcement notices, confirmed CPOs, confirmed revocation orders, and so forth? So I do emphasise the very substantial potential implications of a judgment in the appellant's favour. Finally, a planning permission endures for the land, section 75 of the Act. And as we've said in our case, this planning permission could turn up in the hands, as it were, of a planning authority and an owner 20, 30, 50 years ahead. All the contemporary circumstances will be long lost. An enthusiastic planning authority seeks to enforce, perhaps serve a breach of condition notice, which can take immediate effect and there's no need for an appeal. The potential uncertainty for future owners and planning authorities are to be considered, I respectfully suggest. Better, I say, to leave the document on its face and the conditions that are specified. And my Lord, those are my submissions, unless I've...
Thank you very much, Mr. Lockett-Mummery. Mr. Vanderman, do you have anything to add? Mr. Reid.
Can I deal firstly with the observation that was made by Lord Carnworth in respect of the Aberdeen City and Milne case? And we've had the opportunity to look at that case, and it does, with respect, endorse the approach that was indicated by the court earlier this morning, to the effect that the documents in question that were then being considered obviously indicated what was meant by the relevant documents, and that proved to be the touchstone for the decision in that case. And so I do, with respect, endorse the relevance of the Aberdeen City case. In addition, and I'm aware, of course, this is not strictly reply, but I deal with it for the sake of completeness, and I've given the relevant case to my learned friends. My Lord Carnworth indicated that he thought that there was a case that indicated that if a reason wasn't imposed in respect of a condition attached to a permission, that wouldn't invalidate the permission. And there is a case to that effect. I've given that case, as I say,
What's it called?
It's Brayhead Ascot
Yes,
against Berkshire County Council.
yes.
Thank you.
We have copies of that for the court if
Well, it's
if that would
common
be of
ground.
assistance.
At least I assume it's common ground.
It appears to be. We've checked to see whether or not it has been in any way.
If you've got copies, we might as well have them. Can we?
Give them to the usher.
Thank you.
Thank you. Lord, I don't propose to say anything more about that, save that it does indicate that the observation of Lord Justice Lewison that non-imposition of a condition may have the effect of thereby rendering the condition invalidly imposed would be undermined by the terms of that decision.
Thank you.
Thank you.
Can I deal then firstly with the Secretary of State's case? The Secretary of State, of course, relies heavily on the I'm Your Man decision, but I said it in opening and I repeat it, that I'm Your Man is not determinative of this case, because what it doesn't do specifically is say what amounts to a condition. And that is the question for this court. It is not the ultimate effect if there is not a condition. It is there a condition that has the effect of preventing retail use? And when one understands that that is the critical issue for determination by this court, then one can see that I'm Your Man has only limited relevance to the question. Turning next to the issue of implication dealt with by my friend Mr. Kalinsky. Implication, of course, was not just in Trump. It was suggested by Mr. Kalinsky that there was a turning point by virtue of the Trump decision. But it wasn't just in Trump that implication was identified. It was also in the much earlier cases, as the court has seen in the Francis case and in Crisp. And can I just touch on what my learned friend Mr. Lockhart Mummery said about the Francis decision, where he indicated that Lord Justice Parker went wrong in his analysis by saying that the minister actually had no power to impose the permission that he did. Mr. Lockhart Mummery is wrong, in fact, because actually what Lord Justice Parker was simply pointing out was that if what you wanted to do is have permission that had the effect of preventing the caravan from being used for more than 6 months, then it had to be by way of a condition. And that's why he looked at it as implying that condition. So he was perfectly right in terms of it being a decision that showed that at an earlier stage, much earlier stage in the legislative process, there were decisions identifying implication as being appropriate. And again, I touch on the third respondent's case, but the third respondent, of course, was saying that implication should not be used as an additional tool in the tools available to the decision makers in respect of planning permissions, because it was not something within the statutory scheme. One can see that right at the start of the creation of the town and country planning system, the courts were willing and able to impose implied terms or implied conditions as appropriate. And in my submission, it's now a decided point and shouldn't be rowed back from. But that I return to the points made by the Secretary of State and the interpretation point made by Mr. Kalinsky, referring to the Belize decision, which said that one needed to have a credible position in language and context. It appears that the Secretary of State accepts that the purpose behind the document, the obvious purpose behind the document, was to entail the restriction of the use to non-retail trading only. And that, in my submission, is both a credible approach as a matter of context and a credible approach in the language for the reasons that we've set out. And it's right, of course, that there shouldn't be improvement of a particular document. But if, looking at what it means, it has a particular effect of imposing a condition, then that would be something that is consistent with the lack of an improvement of that document. Can I turn to the nature of the consent itself that we're looking at? It's at page 442. And for fear of simply repeating the observations that the court has made, conditions 2 and 3, when one is looking at what is to be the subject of the development hereby approved within the terms of those conditions, one is obviously looking at the varied condition. It couldn't be anything else. And of course, Mr. Lockhart Mummery's submissions to the effect that, well, what has been done is simply grant a consent subject to the new conditions, and that is all. What that does is just ignore, in my submission, the proposed wording at the top of that page of the document. It has, in my submission, to mean something, and can only mean that there is a variation of the condition.
What do you say about the conditions of the page 434, conditions 2 and 3? Do you say they are superseded, or do they continue?
The ostensible position, of course, is that there was an earlier planning permission. That planning permission is valid. It inures for the
Yes,
for the
and
land
that was
permanently.
implemented.
And the condition would do so as well, unless it was inconsistent with any later permission. And there needn't be an inconsistency between those conditions and the later permission and the earlier conditions. There
So
needn't.
your submission, I mean, we're not having to decide this, your submission would be that for example, the requirement that deliveries should be carried out in accordance with the management of deliveries strategy will continue by virtue of the earlier permission,
Yes,
as long as it's not inconsistent with anything in the new permission.
correct.
Yeah, I see. Well, so there we are. Yeah.
But that it still further supports the point that if one is looking to what conditions 2 and 3 must be referring to, it can only be the varied condition. Otherwise, that part of the document has no meaning at all. It's simply granting something that then reimposes other conditions that are controlling something, on Mr. Lockhart-Mummery's case, but it's not. There's no indication of what it is controlling. Why, for example, simply go through the process of requiring traffic surveys and mitigation for no particular purpose.
Thank you.
Can I turn to the points that are made by Mr. Kalinsky in respect of the Chartbrook principle?
You might want to be selective in the points you deal with in your reply, because there really isn't very long left.
Forgive me, I became carried away, obviously, with my earlier parts, and I see that I have 2 minutes. I can deal with Chartbrook very quickly. I don't accept that I agreed that the document doesn't have irrational effects. It does have irrational effects because it doesn't do that which it was required to do. The fact that on a different perspective, in the Secretary of State's perspective, it may be a legally enforceable document is neither here nor there. It doesn't do what it must do. And Chartbrook looks at outcome. It doesn't look just at the document itself. As to the third respondent's case and the comprehensive nature of legislation, there are other provisions, of course, and one can see them in section 96A and section 56, but one will note that those are both later provisions beyond the 1990 Act, seeking to deal with specific instances where there has been observed to be an omission in the framework itself. And that doesn't provide a basis for preventing the implication in this case. Perhaps the last point that I can deal with sensibly for the court's purposes relates to whether or not there is a grant here of a consent under subsection 2A of section 73. And what one is looking at here is a variation of a condition, but a variation of the condition that was applied for. So if one is trying to make sense of section 73, the only reasonable basis for that analysis has to be the variation applied for, rather than Mr. Lockhart-Mummery's case, which is some other extraneous conditions being attached. So those are the submissions that I make by way of reply, unless I can assist the court further.
Thank you very much indeed, Mr. Reid. Well, this is a very knotty problem. We're grateful to all counsel for their assistance and to those sitting behind them. We'll take time to consider the submissions and issue our judgment in due course.